Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. And today I want to talk about a case that's kind of fun because it has fairly wacky facts. It's the case of the Queen and Dugan. It's from 1974. And it's actually still good law. It's still cited for certain principles. So let's dive right in here. So we see the accused, Donald Jack Dugan, is charged that he, on or about January 7th, 1974, in the municipality of Metropolitan Toronto in the Judicial District of York, unlawfully did have in his possession a quantity of sulphuric acid for a purpose dangerous to the public peace. This fairly dense language is very common for charges. It's how they get written. It mentions the date, mentions the location, as well as the actual specific charge. In this case, he's charged with possession of a weapon for purposes dangerous to the public peace, and that weapon is said to be a quantity of sulphuric acid. So the salient facts which emerged in the trial are as follows. The accused was indicted to be tried with a co-accused before a judge in the county court for a drug offense. The accused wrote a letter with many biblical quotations to the Toronto Star in which he informed them that he intended, if he was convicted, to teach the judge a lesson by committing suicide. The Toronto Star quite properly informed the police, as well as the Crown Attorney's Office, of the contents of the letter, and the police were alerted. On the day of his trial, police officers went to the county court where they discussed the matter with the Crown Attorney, Mr. Frankel. When the accused was seen in the passageway, the police inquired of the Crown Attorney whether they should endeavor to arrest the accused to see whether he had any dangerous substances on him, but the Crown Attorney thought that as there were people in the area, they might have been exposed to danger, so he advised the police not to effect any search at that stage. There were quite a few detectives, as well as spectators, lawyers, and a doctor for the accused in the courtroom. The accused was seen to take a plastic bottle containing sulphuric acid, a corrosive substance, put it in front of him on the dock, and as he was about to put it to his mouth, the police grabbed him in order to retrieve the bottle from the accused. In the process, some of the acid spilled on the co-accused, and 2 policemen were burned, and the clothing of the 2 policemen were also damaged, but eventually they succeeded in taking the acid from the accused. If they hadn't, he probably wouldn't be on trial. The accused did not adduce any evidence to explain his rather bizarre behavior, and the facts were not really in dispute. Counsel for the accused submitted that the accused was only attempting to destroy himself by committing suicide, and as the accused had no intention to injure any member of the public, he could not be guilty of the offenses charged. And before you're inclined to judge the Crown Attorney on this one too harshly, at this stage they wouldn't have known what he had. And, if he had a handgun and they were trying to wrestle it from him in a crowd, that could have gone really badly. Similarly, this acid in a crowd, some people were injured, but it looks like they did a pretty good job in dealing with the scenario here. So I don't really put too much fault on anyone other than Mr. Dugan here. But let's continue on. So the 2 main issues in this case are, first, is sulphuric acid an offensive weapon within the meaning of the criminal code? And what construction must be placed on the words, for a purpose dangerous to the public peace? So they go and they give a definition of weapon here, and this is an outdated definition. It's been updated since then. However, it's close enough to the current definition for our purposes. So they note that it's anything that is designed to be used as a weapon, and anything that a person uses or intends to use as a weapon, whether or not it is designed to be used as a weapon. There's some further bits, but they're not really relevant here. So note, the acid was not designed to be used as a weapon, so it does not fall within paragraph A. Whether it is a weapon under paragraph B depends on the use made or intention to be made of it. In my opinion, the evidence in this case unequivocally indicates the intention of the accused and the actual use by the accused of the acid as a weapon, i.e. for inflicting or threatening injury, albeit to himself. As paragraph 6 is general in its terms and does not restrict the use of the weapon to persons other than its possessor and/or user, I hold that the accused was in possession of an offensive weapon within the meaning of the code. I'm not sure that the court would have reached this same decision in different circumstances. However, these are pretty shocking circumstances when you think about it. It's not only is this sort of a clear show that the guy's putting on, but it's in a courtroom. That's definitely going to make a judge extra angry. The circumstance that this immediately brings to mind is if you've got somebody on a bail condition not to possess any weapons and they try to harm themselves in some fashion, are we going to breach them on the no weapons condition because they've... So I'm not sure that this, had this been being decided now in different contexts, I think that they might have come to a different decision. However, this is the state of the law. And so now I don't think that it's likely to be changed in any real way, absent some action by the courts or by Parliament. There is a dichotomy in our jurisprudence as to the construction to be placed on the words "for a purpose dangerous to the public peace." In the Queen and Flack, which is a decision I will probably cover in a future video, they noted, one of the elements of the offense is the purpose for which the person has or carries the weapon. When he has possession of the weapon lawfully, I do not think an unpremeditated use of the weapon out of sudden anger or annoyance for the forbidden purpose is enough to convert a lawful possession or carrying of it into an unlawful one within the meaning of the section. The formation of the unlawful purpose, which may be inferred from the circumstances in which the weapon is used, must precede its use. The interval of time between the formation of the purpose and the use of the weapon need not be long. It may in some cases be very short, but the gap must be significant. What this means is that possession of a weapon for purposes dangerous to the public peace does not include things that you had for legitimate reasons just because you turned them to some other purpose. So as an example, if there's a construction site and you've got a worker and he's carrying a 2x4 and somebody comes up to this worker and starts insulting them, and the worker then turns around and hits them with the 2x4. The worker at that point is not entitled to hit them with the 2x4 because just an insult isn't typically enough for that. But that doesn't mean that the 2x4 was possessed for a purpose dangerous to the public peace. It was possessed for the purpose of construction, and there wasn't a gap in that sense. Now, if we sort of break this up a little bit, if that same construction worker was done his shift, went to the bar, and at the bar somebody throws those same insults, and he leaves the bar, goes back to the construction site, picks up a 2x4 for the purpose of settling the issue, goes back to the bar, somehow walks his 2x4 past the bouncer and clocks the guy, now he's likely to be convicted of the possession of a weapon for purposes dangerous to the public peace because there's that gap. So that's what they're really talking about here. It's not terribly relevant to this case, however, because in this case, he clearly would have brought the sulphuric acid in for a purpose, for an intention. It wasn't like he was going to do some etching, just beforehand. But the judge here is trying to cover off the state of the law as best he can. So we have, in the Queen and Nelson, the law was fully reviewed by the Court of Appeal comprising 5 judges. In that case, the learned trial judge found that the appellant had possession of the weapon solely for the purpose of self-defense, and therefore acquitted him as the learned judge felt that he was bound by the decision of the Court of Appeal in the Queen and Thornton. The learned Chief Justice held that the fact that the weapon was intended for defensive purposes was itself no answer to the charge. The subjective purpose of the accused is only one of the factors to be considered in deciding the purpose of the possession along with the nature of the weapon, the circumstances of possession, and the use to which it was actually put. Notwithstanding that he accepts the explanation, the trier of fact may find that in all the circumstances, the possession was in fact for a purpose dangerous to the public peace. 3 of the justices of appeal agreed with the ruling of the learned Chief Justice. And I'll note that self-defense is not always held to be a purpose dangerous to the public peace, but it's almost always held to be such a purpose. And the reason why is that the courts have decided that if you have a weapon for self-defense, that you're more likely to get into fights, or those fights are more likely to be dangerous. You may not necessarily agree with this line of thinking. I certainly have my own issues with it, but that's the state of the law. The Thornton case, in a way, modified and explained the ratio dissidende in the Queen and Yaskowicz. The judgment there stated, On this appeal, the accused complained of the conviction upon the ground that the weapons were for the purpose of defense and not for the purpose of offense, and upon the ground that they were assembled in a private place. Both these contentions are, I think, entirely ill-founded. An offensive weapon is defined by the Criminal Code at a section that's no longer the section where it's defined, in terms which amply covered the weapons here in question. It is no answer to the charge that these weapons were intended for defensive purposes. They were offensive weapons. The purpose for which they are used is immaterial save when the crime is committed, when the weapons are possessed for any purpose dangerous to the public peace. So we can see here the court is tightening up on self-defense. In the Queen and Knutson, commenting on the language in Jaskowicz, considered the interpretation placed thereon to be too rigid and said, "It might be construed to mean that a person who kept a firearm in his home because he or she was afraid of burglars, or a man holding public office who in troublous times such as we are going through now kept a firearm in his home because he feared that it might be invaded by persons intent on kidnapping him, had the weapon for a purpose dangerous to the public peace, and so was guilty of a breach of Section 82. I would not therefore decide this case solely because it can be brought within the language quoted when read in a general way." This is a bit of a relaxation of it. We can see here that they're saying that self-defense might not be for a purpose dangerous to the public peace. And the example that they're saying here is, in particular, in your home. Defense of your home or defense of your person in your home is less likely to be found to be a purpose dangerous to the public peace. Ends up being a very complicated issue in a lot of cases, but the court's going to try to resolve it for this particular circumstance in this particular case. I'm going to skip over a bunch here. I'll link the full decision, of course, in the text below. In my opinion, the word purpose is used in a subjective sense to designate those objects which the accused knew would probably be achieved by his act whether he desired them or not. Motives, however benevolent, are immaterial. The fact that the sole purpose of the accused was to commit suicide before a legally constituted court so as to dramatize his trial is irrelevant. On the contrary, his conduct amounted to contempt in the face of the court, as one of the purposes of the accused was to undermine the administration of justice and to bring it into contempt and ridicule. However, the accused was not charged with having the acid in his possession for the purpose of committing an offense. The judge here is suggesting that he could have been charged with having the acid for the purpose of contempt of court. But you can see that the judge is also a little bit ticked off about this guy's plan. He's not happy with the notion of somebody bringing in this acid in order to embarrass the court in some fashion. So that's neither here nor there. And, of course, I'm almost certainly getting demonetized for certain words that appear in this decision, but that is what it is. Was the purpose dangerous to the public peace? In other words, was his attempted suicide dangerous to the public peace, having regard to all the circumstances of the case? And they've got some quotes here that define public peace. Now, a lot of people really sort of lionize or deify Black's Law Dictionary. You'll notice that none of these quotations are from Black's. I own a copy of Black's Law Dictionary. I've opened it, I think, twice for cases. It's not the be-all and end-all, and usually the starting place for dictionaries is much more ordinary dictionaries, such as the New English Dictionary, which is where they start. Public peace may be taken as equivalent to the King's peace in its broader and later signification. The King's peace is the legal name of the normal state of society. The peace is defined in Murray's New English Dictionary as being the King's peace in its wider sense, the general peace and order of the realm as provided for by law. Peace particularly connotes a quiet and harmless behavior towards the king and his people. The king's peace at first only extended to crimes which were the original pleas of the crown, but the king's peace by an easy process extended itself until it had become an all-embracing atmosphere. Can you tell we're kind of in a monarchy? Applied to the internal regulations of a nation, peace imports, in a technical sense, not merely a state of repose or security as opposed to one of violence or warfare, but likewise a state of public order and decorum. I don't know if they'd put as much emphasis on the king or queen's peace in the current era, but it's interesting language in any event. To these I would add the following: peace, a quiet behavior toward the king and his subjects; peace, breach of a violation of that quiet peace and security which is guaranteed by the laws for the personal comfort of the subjects of this kingdom; peace of the king, that security for life and goods which the king promises to all his subjects or others taken into his protection. Applying these definitions, it appears to me that conduct of the kind engaged in by the appellant involving the use or intended use of one of the knives, in the case that they're quoting from here, as a weapon is dangerous to the public peace. Whether it takes place inside or outside a private dwelling, it constitutes a disruption of the normal state of society and a disturbance of the general peace and order of the realm as provided for by law. It is an unquiet and harmful behavior towards the queen and her people. Even if it could be said that, occurring as it did inside a motel unit, it was directed only towards Miss, and this is the name of the accused, it affected her as one of the queen's subjects. Moreover, it was calculated to disturb the peace of persons nearby, one or more of whom might feel the necessity of coming to the woman's assistance. The judge's conclusion is, it is patently clear from the evidence that the accused was determined to bring about his own self-destruction by swallowing the acid, and there was no intention expressed by him to injure any member of the public. He may have caused fear and alarm in the minds of persons in the courtroom, but this is not the test to establish that the purpose of the accused was dangerous to the public peace. The test is the purpose and intention of the accused. See the Queen and Flack. However, the accused ought to have realized, and did in fact realize, that the drama he intended to portray in court was likely, in the circumstances, to provoke physical resistance to his proposed conduct, and that, in the process, persons in the vicinity would be exposed to serious physical injury if and when an attempt was made to frustrate his bizarre plan by the police's endeavor of preventing him from drinking the acid, and as he resisted. As a matter of fact, this is exactly what happened, as disclosed by the evidence. I therefore hold that the Crown has proved beyond a reasonable doubt the offenses charged. The accused is therefore found guilty and convicted accordingly. And unfortunately, this case does not include the sentencing, so we don't know what Mr. Dugan got sentenced to. Now, the reason why this case gets cited still is that suicide is not illegal in Canadian law, but people do still get charged with it. And typically the circumstances are such, especially with firearms, where people are trying to kill themselves in either a public place or in a place where, for instance, an apartment building where, a projectile could continue on and harm someone else, or in situations where someone else might, leap to interrupt things and therefore end up getting injured. It also applies in sort of suicide by cop scenarios where somebody comes out and points either something that looks like a weapon or that is a weapon at police, and the police respond with violence. In those circumstances, they'll almost assuredly find that the weapon was possessed for a purpose dangerous to the public peace. So this case does still get cited for those sorts of reasons, and it's got some life to it, notwithstanding the fact that it's a very old decision. And as mentioned, it's a bit of a weird set of circumstances. It's one of those, criminal law is never boring. There's always something weird and strange happening, and this is an example of one of the weirder scenarios. Anyway, I hope you've enjoyed this case. I hope that you found it interesting and educational. Please like, share, and subscribe if you have. I also want to thank my $10 Patreon supporters: Ma Buddy Keith, Process Eng, Stephen Larson, General Counsel to the CCFR, John Robinson, Tim Rogers, Roy Haddock, Jean-Alexandre Tessier, Cameron Johnson, Sir Goat, Sights and Arms Limited, Shaba Hollow, please tell me if I mispronounced that, and Peter H. Thank you once again. I hope this has armed you with knowledge.